Have you ever used the Specs-to-Pics website? On this website, AI automatically changes the drawings into neat pictures. This is one of the examples of AI creations. In this situation, who do you think owns the copyright? Is it given to us who drew the picture first? Or is it given to the AI who converted it into a new picture?
We researched more about where the copyrights of AI creations belong to. First of all, we have to judge whether to approve AI creations' copyright ability. Current copyright law prescribes literary production as a creative production that expresses human thoughts and emotions. It also prescribes an author as a person who creates a creation. On this occasion, AI is not a person, so it cannot be an author. Creations made by humans using AI as a tool are acknowledged as human creations. However, AI creations that people didn't intervene in are not acknowledged as a creation, and therefore nobody is given the copyright. If the companies that developed AI systems are not given any copyright for pure AI creations, there may be concerns about AI development. In contrast, if we acknowledge AI creations in all, major companies can strengthen their leverage by creating numerous productions using AI and monopolize creation industry due to capital. Thus, human creators can be threatened.
There was an incident when Insun Company reposted an article written by an AI program called DreamWriter, owned by Tencent Company, on their homepage without permission. Chinese Shenzhen courts acknowledged copyright infringement and sentenced Insun to compensate for all the damages. These are why China approved the copyright ability of AI creations. First, the article had reasonable structure, logical expressions, and originality. Second, the Tencent created the main creation team and created the article with using DreamWriter. Lastly, most writing processes were selected and arranged by the main creation team, which is directly related to the specific expressions of the article, which is equivalent to the creation. To conclude, the Chinese court judged that AI was only used as a tool for creation because the article was created by Tencent's order, which can be seen as a human's choice.
We should also look at why the copyright was vested in Tencent. In this instance, the Chinese court viewed this article as work made for hire. According to Korea's Copyright Act, Article 2, Note 31, the term work made for hire means a creation made by an employee of a legal person during the course of his or her duties and on the initiative of a legal person. Presently, AI creations are similar to work made for hire because they are both made under the company's plan. However, there is a limitation to apply this to AI because a person in business is also premised in human, and the article is invoked only when there are no other definitions under contract or working rules. Nevertheless, China viewed this article as a work made for hire. Under the Chinese copyright law, the creations organized and created by the corporation's intentions are regarded as literary productions. The same applies to creations which a corporation is responsible for. The fact that the main creation team divided labor and inspection for the creation supported the Chinese court. Consequently, the Chinese court granted Tencent the copyright of this article.
Furthermore, there is an argument to protect AI copyright by applying the Unfair Competition Prevention and Trade Secret Protection Act. Article 2, subparagraph 1, 11th clause of this act states, any other acts of infringing on other persons' economic interests by using the outcomes and more achieved by them through substantial investment or efforts for one's own business without permission, in a manner contrary to fair commercial practice or competition order, as an act of unfair competition. That is, if this clause is applied, the company's interests can be protected even if the copyright of AI creations is not acknowledged. However, there are also limits to this view. First, when someone uses AI creations without permission, it is necessary to discuss whether it is illegal to the extent that it is against fair commercial practice or competition order. Next, even if this act is applied, it cannot prevent individual abuse because AI creations are only protected against unauthorized use for business.
Japan Intellectual Property Strategy Headquarters divided the protectiveness of AI creations into 3 sections according to human involvement and mentioned its copyrights. Firstly, When humans use AI only as a tool, the program that AI made is protected as a creation. Secondly, when AI provides creation service to users, and users are provided the contents with simple management. Aforementioned, Tencent's controversy corresponds to this. Since there is little users' efforts and investment interference, and AI programmers can retrieve investment costs as service charge. So, Japan mentioned that the necessity of copyright protection is law. The last situation is when someone buys an AI program itself. When AI programmer gives AI subjectivity and sells it, the buyer has all the authority that the AI program made.
Japan is under discussion on how far they will assign authority in protecting AI creations. Opinions are being proposed to provide legal protection, such as trademarks, for creations made by AI programmers. In addition, Japan takes a position to minimize impacts that will affect human society by making a difference in the protection period. Notably, Japan's protection period is 50 years after the creator's death.
Copyrights of England are protecting computer-generated inventions. There is a possibility of protecting AI creations too. Computer-generated inventions are creations that computers have made without the involvement of humans. The copyrights in Britain grant the copyright of computer-generated inventions to the person who has taken the steps required for creation and protects it for 50 years. When the law was amended in 1988, there were a lot of involvement and controls of humans unlike today. Thus, if this clause is applied to current AI creations that produce numerous creations through deep learning with little human involvement, it can give artificial intelligence excessive monopolistic strengths, which has the potential to harm the public interest. Nations such as Korea, Japan, China, and France follow the continental law, which focuses on people when interpreting copyrights. That means they exclusively grant the copyrights only if the creation is made by humans. In contrast, nations such as America, England, Australia, and Singapore are describing copyrights centrally on literary productions. If the creation has creativity, it is entitled to copyright. The reason is that they consider it as a privilege to get property interest by creation.
So far, we have looked whether AI creations can be recognized as literary productions, and if so, who will be given the copyright. This issue is a controversial issue that could lead to decline in AI development or monopoly in AI creation. Undoubtedly, AI creations will be rampant in the near future, so we need to further refine the current legal system. Thank you.